Hello everyone, welcome back to LaExcellence Bengaluru presents current issue of the day, episode number 168. Today we'll be discussing a very important topic, that is the International Court of Justice and its recent advisory on the climate change, which is considered to be a turning point in global environmental justice. We will see what is this advisory is and how it is going to impact the climate change and what are its relation with respect to India. Does India already have a legislation similar to this or not? All these things will be covered today. Next, so in syllabus it comes under GS3 environment ecology and can also be covered in GS2 international institutions. So context is, on July 23, 2025, the International Court of Justice issued a landmark advisory opinion clarifying the legal obligations, very important, the legal obligations of the states to address climate change, protect ecosystems and ensure intergenerational equity. The opinion came in response to a United Nations General Assembly request backed by 130 countries, led by Vanuatu and other climate vulnerable nations. Okay, here the opinion is that legal obligations of the states to address climate change, that is certain conditions are there which are binding on the states and it has to be, so they are legal obligations on the states and the state has to implement those. So we will see what are these obligations and what is the opinion about. First we'll understand what is ICJ. ICJ is International Court of Justice, full name, okay, that is it function, principal judicial organ of the United Nations, headquartered at Hague, the Netherlands. Type of ruling, it is only advisory in nature, advisory opinions. So the current opinion is also advisory, so that is why I refuse to use the word binding there. Next, non-binding but legally persuasive and norm setting, meaning once the opinion of ICJ is issued, this can be used as a persuasion or norm setting by the different countries to bring in legislations which can serve as an inspiration. Next, the past impact is legal framework for nuclear disarmament, colonial reparations and environmental responsibility. So even though it is non-binding, the opinions of the International Court of Justice are very significant. Okay, as a result, the non-nuclear disarmament treaties have come, that is NPT and CTBT, and colonial reparations have been come, and also environmental responsibility has also become a thing now. Now, in the current context, the advisory of the ICJ deals with different aspects. So, the key takeaways from the ICJ advisory opinion. First is nature as a climate actor. Ecosystems are not just the victims of the climate change but also active regulators according to ICJ. Carbon sinks, rainmakers and buffers. Next is forest absorb CO2 and regulate monsoons. Okay, so nature is not just the victims but also a regulator. Even if you exploit it, it is going to help you deal with climate change. Next is the legal duty to protect nature. That is, the states are obligated under the international law to preserve biodiversity and ecosystems as part of climate mitigation. They are obligated legally. Safeguarding wetlands to prevent floods, that is an example. And ecocentric justice, that is legal frameworks must shift from anthropocentric to ecocentric justice, including recognition of rights of the nature. A very important observation here. They are not just talking about preservation of the nature just because you have to preserve it. Preservation of nature because it is the right of the nature to be preserved. You have to keep the nature preserved because they also have certain innate rights. That is legal personhood to rivers such as River Ganga in India and Wanganul in New Zealand. Next is no trade-off between biodiversity and climate. That is, climate projects like solar farms should not harm biodiversity. The irony here, that is, you are trying to fight the climate change by installing solar powers, but its impact, it is on the biodiversity, which is also part of the nature, which or who have their own rights as well, so which are being violated under these climate projects. So that should not be the norm here. Avoid locating solar parks on the grasslands so that the biodiversity of grassland is not affected. ecological literacy for the decision makers. That is, judges, policy makers and planners must understand ecological independence, ecological interdependencies. Next is example, recognizing mangroves as flood barriers. Okay, they have their own role in the nature to play, that should be appreciated and recognized. Next is intergenerational equity. Climate inaction today violates the rights of the future generations. That is why we should focus on sustainable development. That is, the rights of the future are not violated for the need of the present. Basis for youth-led climate litigations worldwide. So very important advisory is given by the ICJ, which covers all the aspects. So two important aspects which you have to remember here is, nature is not just a victim, it is also an actor. It is not just like movie actor, it is an active regulator. And then is rights of the nature has to be recognized. And finally, we can talk about rights of the future generations as well. A very important key aspects which you can quote in your answers, be it essay, ethics or GS. Okay. Next, what does this mean for India? In India, there is constitutional backing as well. That is, under Article 21, right to life includes right to clean and healthy environment, which was upheld by Supreme Court in Subhash Kumar versus State of Bihar in 1991. So, whatever the advisories that the Supreme, like ICJ has given now, has been already upheld by Supreme Court in the past judgments. Next is Article 48A, which is a DPSP, which says that it directs the state to protect and improve the environment and safeguard forests for wildlife. So the advisories given by the ICJ were already present in India, but what is lacking is its implementation. So we will see that as well. Next is India's policy gaps and opportunities. First is with respect to EIA process, that is Environmental Impact Assessment process. Draft EIA 2020 weakened the checks, bypassed tribal voices. Okay, in the new EIA 2020 draft, they reduced the time period for consultation, that is public consultation was one of the step under environment impact assessment, and assessment in that public consultation the voices of tribals were most of the times neglected. So that has diluted the EIA. So needed action is there should be transparent science-based assessments of a particular project. Next, in forest conservation, FCA 2023 amendments allowed commercial use in certain forest. Okay. Next is reinforce ecological valuation in approvals. So the newer laws that our government of India is doing, or the amendments that the government of India is bringing, or most of the times diluting the restrictions. They are diluting the restrictions and they are allowing for more development and economy oriented policies. So the policy is that we should focus on protection of environment as well. Next is air pollution laws. In air pollution laws, the enforcement is very weak and the act is outdated, which was brought in 1981. Therefore, the need is for real-time monitoring and strong penalties should also be enforced. Tribal participation, very important. That is, the tribal participation has been very limited in national climate policies. Even though they are the major stakeholders in climate change or policy, or nature or climate policies, they are sidelined. Their voices are not heard. So, moving forward, there should be community-led conservation. Next is legal rights for nature, only symbolic in so far. So in moving forward, codify rights of the rivers, forest and ecosystems in domestic laws. Okay, so in a nutshell, we should focus, or we should bring our policy in resonance with deep ecologism. Okay, in ecologism there are two principles, one is deep ecologism and second one is shallow ecologism. In shallow ecologism, we consider the nature or the product of environment and ecology, for our own views. We consider them as only tools for our use. However, in deep ecologism, we consider them at the center. They are at the center and we are around it as a spoke. So we use them for our purpose and they are not there for our purpose. Okay. So deep ecologism considers the right of the forest, the right of the rivers, right of biodiversity. So we should move from shallow ecologism, which is present at the current India, to deep ecologism. Okay, these topics or deep ecologism, shallow ecologism, you can use in your answers as well. Next is the role of tribals in climate resilience. One of the aspect in India was that tribals' role has been most of the times neglected. However, the tribal role is prevalent in India from the ancient times. So recent tribal climate resilience was contribution is with respect to traditional water management. The tribe or region is Bills in Madhya Pradesh. The impact was drought resilience through tanks and wells. So they are also playing a significant role. Next is with respect to forest guardianship in Dongriya Kond, Odisha. That is protection of Niyamgiri biodiversity, which was a famous case with respect to Niyamgiri, Dongriya Konds of Niyamgiri Hills versus the POSCO company, which is a South Korean company which came there for mining, which was finally defeated and sent back, and as a result we are not able to carry forward the developmental activities, but we were able to safeguard the rights of this Niyamgiri Kond of Odisha. Next, sustainable farming is with respect to Apatani of Arunachal Pradesh, wetland rice cultivation with fish as well. Okay, so students of anthropology who wrote mains in the last year might have heard about this one. There was a 10-marker question about Apatani of Arunachal Pradesh. So you can use this in your anthropology answers as well. Next is climate adoption. That is Kutch women of Gujarat check dams water harvesting was used for climate adoption. Next is with respect to policy participation. The scheme is the One Dhan Yojana, where it boosted tribal economy through forest produce. That is One Dhan. The products of the one is forest. The products of one were allowed to be used by tribals. Okay, so these are some of the examples which you can quote in your answers, which is going to boost your answers, which will help you fetch those 2-3 extra marks. Next is the way forward. What should be the way forward for India? But before that, we will understand legal and ethical implications at the international law and the domestic policy. Though ICJ opinions are non-binding in nature, they set soft law precedents influencing future treaties and national laws. So the opinions which were given by the ICJ can be seen in the future of India or future of any other nations, whereby they can provide rights of the or recognize the rights of the nature as well. Next, rights of nature movement. This aligns with India's evolving legal traditions. For example, Uttarakhand High Court recently, around 2018, recognized Ganga and Yamuna as a legal persons or living entities. However, the Supreme Court said that rivers do not have the life or not living entities, but the precedent has been set by Uttarakhand High Court. This can be seen in many other courts in the moving forward. And then is litigation gateway. The opinion could strengthen public, that is PILs, public interest litigations filed in Indian courts on the climate inaction. Okay, these people who are going to put PILs can quote the opinion of ICJ as a way for or as a basis for PILs. Next is justice for future generations. Reinforces India's common but differentiated responsibilities in global climate negotiations. Okay, so whatever the opinion that has been given by ICJ, they were present in India but were lacking in implementation. So what should be the way forward? The way forward should be focused on these aspects. One is codify climate duties in law. That is, enact a climate responsibility act defining role of center, state, local bodies in emissions reductions and adoption. And along with that, we should also focus on duties of the citizenry as well. Okay, duties of citizenry should also be taken into consideration. We should try to bring a behavioral change. Unless and until there is a change from the grassroots, nothing is going to change. So we should go from a grassroots level. Next is judicial and bureaucratic training. Promotes ecological literacy among the decision makers. Includes biodiversity models in civil service training. Next is empower eco-justice institutions. Strengthen National Green Tribunal with more autonomy, resources and ecological expertise. Next is mainstream traditional knowledge, recognize and institutionalize tribal and local conservation practices in forest and agricultural policy. Next is rights of the nature legislation. Pilot legislation to grant legal status to key ecosystems, empowering citizens to act as legal guardians like Ecuador and Bolivia. That is rights of the nature legislation. Whenever you are going to write an answer with respect to environment, now try to include this aspect as well. That is rights of the nature and rights of the future. These are the two aspects that should be there in your answers. And also you can include the deep ecologism principle. Okay, so the way forward and the concept here is very important. There have been a very beautiful opinions given by the ICJ. That is why I have covered this topic. You can use this in your answers. You can quote this in your answers, essay, etc. So if you like the video, then please hit the like button, comment on it, and also share with your friends. And if you are new to the channel, please subscribe to the channel and also click on the bell icon so that you don't miss any notification. With this, I will end the video. Jai Hind.